Now, I'd say that was treason on his face. The judge has just committed.
Yeah.
Well,
I've been accused.
I'm a living man.
Stop. I'm talking now. I've been accused of committing treason before, not committing treason. Everything you just said is nonsense, and it is not applicable in this court. I'm standing to talk, so I'm going to let you stand there, but that is all I'm going to let you do. You can't say any words today.
I am appearing next, Brent.
You are not, because that is not permitted by the Michigan court rules. You can stand there, like I said, I'll let you do, but if you keep talking, I'm going to make you sit down.
My name is Christopher Allen Renfro. Today, I am demanding vacate these matters, for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. That's my statement. I demand the court to vacate these matters and restore me whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. Coming into the courtroom, PCCs. All right, and so this is case number 25T01947FY, People of the State of Michigan versus Robert Wayne Sigby. And counsel, you can place your appearance on the record.
Good afternoon, Your Honor. Mitchell Young for the people.
And Mr. Sigby, you can state your name, please.
Robert Wayne Sigby.
All right.
Yeah.
And
Executor, beneficiary, kind of formal.
all right. And we are here today on a probable cause conference. We had a hearing on July 31st. At that point, Mr. Sigby had stated that he was going to be wanted to represent himself. We had a long conversation about that at that time. And I did determine that Mr. Sigby would be permitted to represent himself and that Attorney Hilliker would no longer be appointed on the case to represent Mr. Sigby. And so then at that time, Mr. Sigby, you stated that there was some more discovery that you were looking for, body cams and some other things. And so we adjourned to today's date, and then we find ourselves here today. So on that note, Mr. Sigby, do you have all the discovery that you were looking for?
I do not. I wanted to confer with the prosecutor, and I had more paperwork to turn in, and I worked tirelessly to get the paperwork in. I got it in. There was no more overnight mailing. So I got it in on Tuesday. I don't know if the prosecutor, David Layton, had received the add-on to the paperwork. I see this prosecutor here has zero paperwork in front of him. So he didn't even get the first paperwork that or all of it was sent in. I don't know, Mr. Prosecutor, did you receive any paperwork?
I think they do everything they have a system called Carpel where they do everything digitally. So if he does have a digital file with your paperwork in it, probably
It looked like this.
I believe, Attorney Young.
Your Honor, I'm unaware of anything that was given to our office. My understanding is that Attorney Hilliker provided all the discovery that we gave to him to Mr. Sigby, and from there he has everything that we have at this time. We did provide Attorney Hilliker the body cam of Officer Isaiah Voorhees, and that is all I have in regards to body worn camera at this time.
But
Yeah, I want to be respectful.
thank you.
So what I said in the last PCC, seeing as how we don't have a Fifth Amendment indictment here, we're going through this process. I feel it's very constitutional not to have an indictment. There was supposed to be body cameras from the other officers, roughly between 9 and 12. I could hardly count how many police were there because of what has happened on the side of the road, it would exonerate me if I had different views of the behavior and the actions of the arresting officer in this civil infraction.
All right,
The
so,
fruit of the poisonous tree has been definitely happened.
Your Honor, if I may, I'm obviously not an expert on the facts of this case as I'm just covering today, but my understanding is that the body cam of the arresting officer was provided, being Isaiah Voorhees.
If I may.
okay, well, hold on, let me ask a question. So on that one body camera of the arresting officer, do you have that, Mr. Sigby?
I do.
Okay,
and
so you have the one, it's just the other ones that you
Right.
want, okay.
Exactly, because what the deputy did is he concealed he put his body camera on this side of me and blocked it while he reached into my bag and into my pockets. I was cuffed. And he reached in the pocket. I looked down and seen him pull out my Native American herb. And then he stuffed it back in my pocket, but I thought he took it with everything else and threw it into the vehicle. So that right there would exonerate me that I did not bring nothing into the jails. He did.
No malice, nor.
Okay, nope. Mr. Renfro, you don't have any standing to talk, so I'm gonna let you stand there, but that is all I'm gonna let you do. You can't say any words today.
I am appearing next, Brent.
You are not, because that is not permitted by the Michigan court rules. You can stand there, like I said, I'll let you do, but if you keep talking, I'm gonna make you sit down, and then if you don't follow those rules, I'm gonna have those nice gentlemen back there escort you out of the room,
Thank you.
okay? So, remember, my rules, my court, it's just how it works. Okay.
Objection. I'd like to have an objection.
Sure.
The definition of court here is the person in suit of the sovereign, the place where the sovereign sojourns with his regal retinue. This is my retinue. Black Law's Dictionary is cognizable by the Congress.
All right, this is the 67th District Court. I'm the judge of the 67th District Court, and that's all I'm gonna say about that. Okay, so whatever that objection is, it's overruled. Okay, let's get back to the issue at hand, though. The issue at hand is that Mr. Sigby would like some additional body camera footage. Attorney Young, I know that you weren't here last time on this case, right? It was a different, I think it was Attorney Trummer, I think.
I believe so, Your Honor.
All right.
It's either him or Attorney Pokerakis.
So here is what I'm going to say today, what I'm going to order today is I do think that it is relevant, and I think that it is pertinent if there are other body cameras available of officers that were there on scene, then I do believe those need to be turned over to Mr. Sigby because I do find them to be relevant. And I think that it's not unreasonable to want those things prior to the preliminary examination. So I am going to order that those be turned over. I'm also going to state, though, that the discovery is what the discovery is. And so sometimes there are situations where people think there is additional discovery that does not exist. So if there is 5 body cameras, then there's 5 body cameras. And if that's what the prosecutor's office says that that's all they have, then that's all they have. So we're gonna order that everything the prosecutor's office has needs to be turned over. If there are additional body camera, they need to get that and they need to turn that over. But we're not going to continue to have a conversation over and over again about discovery that needs to be, or that discovery that Mr. Sigby you think might exist that doesn't exist. So when we come back next time, I'm going to expect the prosecutor's office to turn over everything they have, and then we will move on to the preliminary examination phase, because we got to start moving this case along at some point.
So Michigan,
Hold on one second. Attorney Young, how long do you think it will take your office to get that additional information for Mr. Sigby?
Seeing that this is the Genesee County Sheriff's Office, I should be able to get it relatively quickly. However, the videos would need to be reviewed prior to release. I'm thinking 2 weeks would be more than enough time. I could probably do it if I'm lucky by the end of this week, really to get them. So I'll leave it to the court and I'll get it done. But I'd say either a week or two.
Right.
Be sufficient.
Mr. Sixby?
So the problem I have is, a couple of them, is, one, Michigan State Constitution says I get to confer with the prosecuting office. I'd like to do that.
Sure.
And then another thing is, on a scene such as that one, you'd think every one of these cops would have, police officers would have their body cameras running. So if he wants to look at them ahead of time and said there is none, no evidence, I'd say that was conspiracy against my rights at that time under United States Code 18 U.S.C. 41.
But we're not even there yet.
I get it, I get it.
So,
But okay, the video I got, there's a chunk in there where he says if this man would have been by himself, I would have, and it went blank. You can see the lips moving, but you can't hear nothing. So the editing process is taking away exculpatory evidence.
those are things, so
If he
Those
threatened me with death,
those are the things, whatever happened, those are the things that get brought up in front of the jury. You can bring them up in front of your preliminary examination as well, but they get brought up in front of the jury to show weight of evidence. If you're claiming there's evidence that's missing and things like that, those things absolutely can be brought up. It's just that we're not going to prevent having a preliminary examination by saying that you think that there's evidence out there that they're saying that they don't have. Do you see what I'm saying? So once they say, this is all we have, these are all the cameras, then we are going to have the preliminary examination. That's all I'm saying. So we're going to give you time to do that though, and give you time to talk to the prosecutor's office
Sure.
once you have that information. All right. So having said that, let's pick a date for the next court date. I think Attorney Young, you're right. I think to get the information to Mr. Sigsby and then give Mr. Sigsby and the prosecutor's office, everybody time to review everything and then give the parties time to talk if they want to. I think that setting this for one more probable cause conference, I will find good cause to do so. I do think that's a good idea. And I'm looking at September 4th. Does that sound like a good day to everyone?
well, I'd like to get 21 days so I could send the prosecutor a proper notice of non-response.
That is appropriate.
Oh, you got good math.
Do you want, I can give you a little bit, we can put it on the 11th.
Well,
if you want. Give you a
I
little
would
bit
like it on the 11th. The reason being, because I'm going to send a bill of particulars. If this county does not recognize Fifth Amendment indictment, then they're going to have the bill of particulars, because without that, the substantive due process has been violated on its face. There is no indictment on this felony charges, and it is the fruit of the poisonous tree. So I'm concerned that the Constitution of the United States is not being followed on its face by all
Yeah.
parties.
Here's
It's a
what-
point of order.
So
Point of order is a real, what, I got to get it out of the law book again?
I've looked at Mr. Sigsby, I've looked at everything that you filed. In fact, not only have I looked at it, I've highlighted it, and I've even made my own notes.
I see you.
So please know that I do read everything that's put in front of me and
That's
I
blessed.
take it seriously.
Thank you.
But a lot of what you filed is not relevant nor pertinent nor accurate law in any way. And a lot of it too, it's not filed properly in the sense of this. You have to file it as a motion. So if you do have a motion, we'll hear your motion at the next court hearing, okay? But it has to be filed as a motion. For example, some of these things like a judicial notice of adjudicative facts, notice and demand to cease and desist inland piracy.
I'm not an attorney.
Hold on. I'll let you say it when I'm done. It's nonsense. It's nonsense and I'm not gonna address it. Notice of document filing, things, affidavit of truth. One thing I did want to point out to you, you filed your birth certificate in this file. This is a public file. So people could go and get a copy of your birth certificate because it's right here in this paperwork. I would have not done that. I'm not giving you legal advice in any way, but that just doesn't seem like that's a good idea. I just wanted to point that out to you because when I saw that, I thought, that's not. I also have this appearance of next friend and these things they're just not.
They're
They're
Supreme
not-
Court.
Hold on, stop. I'm gonna let you say those things in just a second. They're not permitted under the Michigan court rules. There's no statute that permits things like this to be filed, and frankly, there's not going to be, I'm not going to spend a lot of time addressing them because they're not relevant to these hearings in any way. I just wanted to let you know that.
All right, I object on the record, be reserved on the record. To correct the record, the supremacy clause of the United States does bind you to all of this. Article 6, clause 2, you're in breach of that clause for saying Michigan does not recognize these. These are, you guys are foreign citizens. Title 28, 22, United States Code, Foreign Relationships and Intercourse. Chapter 11 identifies all public officials as foreign agents. Federal Rules of Civil Procedures 4J states that all courts, jurisdictions, and immunities fall under foreign state. 22 CFR 92.12-13, foreign relationships state an oath is required to take office. The 11th Amendment, foreign citizens cannot invoke the judicial powers of the state. 28 USC 3002-15-8 defines the United States means a federal corporation. Michigan is a franchise, and so is this subdivision is a franchise of a federal corporation. Corporations have no parity with the tangible in Howard versus Dolan's administration. Governmental actors are foreclosed from creating and attaining parity with the tangible. These are res judicata, Supreme Court laws of the land. Now, I'd say that was treason on its face. The judge has just committed.
Yeah.
Well,
I've been accused.
I'm a living man.
Stop. I'm talking now. I've been accused of committing treason before, not committing treason. Everything you just said is nonsense, and it is not applicable in this court. We're gonna leave it at that. We have a court date now set for September 11th, 2025 at 11 o'clock a.m. That will be a probable cause conference. We will be, hold on, let me see where we'll be. We will be back here in Burton on that day. So we'll be here in Burton. For probable cause conference. Any motions that anyone wants to file, try to get filed by that time, though I'm not doing motion cutoff or anything of that nature, but it'd be a good time for us to discuss those things. We're not going to discuss any of this again because I have addressed it and found it to be irrelevant to this criminal case today. And anything else from anybody?
I do.
Yes, Your Honor, just briefly. As is our typical office policy with pro per defendants, I will, once I have the body cam for Mr. Sigsby, I'll have it on a flash drive and I'll hand deliver it to him in court at the next court date. It seems to be the best way to give that discovery. Unless there's another idea.
Can he pick it up at like a clerk's office or something like that?
I don't see why not.
The problem is that we're gonna adjourn it out almost a month. And
Yeah, I don't see why
we're gonna have
not.
to adjourn it again for him to review it, so I don't like that idea.
And I guess I just don't know how I would, well, I think Mr. Hilliker gave us his address. I don't know how I would be able to contact.
Mr. Sigby, what's your opinion on that?
Well, yeah, I don't want no improper service here, you know, Michigan. Michigan,
Let's.
If there's gonna be an issue with
How do you
service.
want it, how do you want it provided to you?
I will meet up with him at a conference. I'd like to have a conference with the prosecutor.
Well, you're
Well,
gonna.
it says so. It
Schedule
says so in
that.
Michigan State Constitution. Let me pull up paperwork.
No.
I just-
No, stop. All we're talking about, I'm not talking about conferences right now. I'm just talking about getting discovery to people. So if the prosecutor's office, you know what? No, we'll do it this way. It's the only other thing we can do is I'm going to move the PCC. We're gonna have a PCC on August 28th, 2025 at 11 o'clock a.m. That will be to exchange discovery. Okay. So that way we can do it here in the courtroom. There won't be any questions about it. I don't want to put any staff member in a precarious position being accused of things that not delivering things or something along those lines. I don't want to put anybody in that position. So we'll just come back here on August 28th 2025, 11 o'clock a.m. We'll have a very brief probable cause conference, and that will only be the exchange discovery. If there are any other issues in regards to discovery, we can talk about them too, and then we'll also have another PCC on the 11th. That will give you opportunity.
That answered my next question. That did answer my next question.
Okay.
Okay, because I
Okay.
just want opportunity, and I do object to the prosecutor using the pro se. I'm not pro se, I'm sui juris.
Sure.
Thank you.
However you want to say. Representing yourself, sui juris, pro se,
Myself,
On
I'm not
myself.
Civil War II, so I'm not a civil dead.
presenting
Child
myself,
justice.
all those things. They all mean the same thing. Okay. Thank you, everybody.
Okay, thanks.
All right, I have 3 files here. I have it's like 2 civil infractions, 1 misdemeanor case. Misdemeanor file is 25F00373OM. People in the city of Burton versus Christopher Allen Renfro, and then the 2 civil infractions, 25F00141OI and 25F00394OI. People of the city of Burton versus Christopher Allen Renfro. And Attorney Odette.
Good afternoon, Your Honor. This is the time set for a pretrial and possible motion hearing. I received no motions. I don't anticipate there being any at this time. And we're just asking if we continue to the jury trial date, as my associate has indicated that Mr. Renfro is not inclined to accept any sort of offer.
All right, thank you for that. And then Mr. Renfro, can you go ahead and state your name for the record?
My name is Christopher Allen Renfro. Today, I am demanding a vacate of these matters, for I still do not consent. The jury trial is not a grand jury, so it would be a violation of the provisions of the Constitution of the United States of America. Also, the traffic tickets were not criminal, which this jurisdiction is for criminals, so I'd like those vacated also. No, there was no proof nor burden that the testimony of the cop was proved to be true, and also no evidence. I still have not gotten discovery, which means it doesn't sound like the plaintiff is ready to move forward either. So that's my statement. I demand the court to vacate these matters and restore them whole again.
All right, thank you. So most of what you stated is incorrect, and I'm denying your request to vacate or dismiss. The proper term would be dismiss, but denying that request. One thing that you did mention, though, that I do want to talk about is the discovery issue. And so is there any discovery that Mr. Renfro made that he does not have?
There's a police report in the criminal matter, and then the tickets that he received.
Has that been provided?
I have no way to provide that to Mr. Renfro. He offered it to them previously, and we did not have to take that.
How would you like that to be given to you, sir?
Well, the 24th was the cutoff, so we're past the cutoff, and that means that there's no discovery on either side.
What it means is that the rules in this court are set by me, and if you want discovery, don't remember, we don't interrupt each other. If you want discovery, because you just stated you wanted discovery, so if you want discovery, I'm gonna make sure it happens. So if you want discovery, how do you want to give it to you?
I don't. We're past the cutoff line, and I want to vacate.
He doesn't want it. All right, well, if you don't want discovery, that's fine. In regards to work, also I want to mention,
The core concept in legal decision-making is procedural waiver. When someone knowingly refuses access to evidence, they lose the ability to later claim they were denied it. Here, rejecting discovery may feel like control, but it removes a key defense tool and limits future arguments about fairness or incomplete evidence.
not right, but somewhat maybe along the path towards that somewhere when you stated the thing about the civil infractions. So you're right, civil infractions are not criminal matters. They are civil infractions for a reason because they don't carry any penalty of going to jail or anything like that. And so you are entitled to a jury trial on the civil infractions. You are entitled to a formal hearing. So my plan would be to have the formal hearings either before or after, depending on how it works out, the jury trial on the misdemeanor matter. Attorney Odette, do you have any objection to
I
that?
have none, Your Honor, thank you.
All right, and Mr. Renfro, I know you don't want to be here, you don't want to do any of this, you don't consent to anything, but nobody here on a criminal case really consents to it. So is that all right if we do those things at the same time, or would you prefer to come back on different days?
Consent comes from the Declaration of Independence. Their second paragraph down talks about the consent to be governed, and also William Lynch letters talks about when slavery ended, commerce was created. What differentiated the two was consent. So maybe we need to go back to our books.
That is a very interesting concept. If, again, incorrect. Also, Declaration of Independence isn't law. Declaration of Independence was a declaration that we made to King England about what we wanted to see happen in this country. So that's not law. I wouldn't quote that anymore. I would
Three
quote
reasons why
other
they went to
things.
war with England.
One more
was
time.
freedom in America.
Don't interrupt each other. We're gonna keep doing this, and I'm gonna keep reminding you of that, because if you try to do it while we're having a jury trial, I'm gonna shut it down way faster, because we're not gonna do it in front of a jury. All right, so again, remember, we don't interrupt each other. So let's go back to the question, which was, would you like to do the jury trial and the formals on the civil infractions on the same day, or would you like to do them on different days? That's the only answer I need right now.
Proceed how you feel, because you already have, so.
Okay, I agree with that. So we will set them for the same day. I think that will be more convenient for everyone involved,
Thank
and
you, Your Honor.
we do try to be convenient for people around here. Okay, and so let's set this then for.
I believe it's already set. I believe there's already notice for the, but I don't believe it was on 8 set, I mean.
But it was not set for today.
If we set this for August 7th, Mr. Renfro, is that an acceptable, and I know no date is acceptable to you, but are you free on August 7th?
On summons, I'll be here.
Okay, all right, you'll get a notice. We won't send you a summons, but we will send you a notice for you.
Only summons this little bit.
Well, if you don't show up, I'm gonna issue a bench warrant for your arrest, so be fair warned. August 7th, jury trial, 2025, August 7th at 8:30 a.m. That will also be the same date for the formal hearings on the civil infractions. And like I said, I'm not real sure which ones we'll do first or last, but I'm thinking we'll probably do the jury trial first so we can get the jury in and out of here, and then we'll move on to the civil infractions. That way, if we have to come back the next day on the civil infractions, we don't have to bring the jury back. Last thing before we leave, Attorney Odette, you mentioned that, actually, there's two more things I want to talk about before we leave. One, you mentioned that today was set for pre-trial and motion, and I do have, as well have, there was no stuff for motions, but I don't have any written motions filed. Did either of you file any written motions?
I did not, Your Honor.
Did you? Mr. Renfro?
No, I do not.
No? Okay, all right, so I don't know why that was set for that. I know you made an oral motion today, but, all right. Well, then that's not an issue. I will also note that right now, the jury trial actually has a date for Friday, September 5th at 9 o'clock.
Yes, that was the date that we subpoenaed.
That is the date of Mr. Becker's trial.
Okay,
When we originally scheduled it to coincide,
gotcha,
and it just kept moving forward.
gotcha. All right, so we want to do August 7th or September 5th? It's like either day is gonna be fine.
Well, I think of course discretion.
I'd say August 7th is good a date as any, so we're gonna, we had it originally set for, I think it was, July 25th, we had to move it because there was some kind of emergency or something. I don't remember what happened on that date, but it was something weird. So then we moved it, but we'll move it back to August 7th. That way we can get Mr. Renfro in a little bit sooner rather than later. I think those are all the things that I wanted to cover, except one more time, Mr. Renfro, I know we've already talked about this, but it is your intention to represent yourself in this matter, is that true?
It is my intention to present this cause.
Okay, you do not want me to ask the public defender's office to appoint you an attorney, is that right? You don't want that, right? And you do not want to retain an attorney, is that right?
Correct, I'm competent and I will see these matters through myself.
All right, you understand, I know we've talked about this before, but you understand that Attorney Odette and people that work in our office that are lawyers have law degrees, they've been through law school, they've been doing this for many years, and according to the people in the legal system, you are gonna place yourself at a significant advantage by representing yourself. Do you understand that?
Advantage? Yes.
A disadvantage. I'm sorry, I didn't say advantage, I meant disadvantage.
I see it another way, but that's.
And that's fine, that's why people represent themselves, they think that they can do it, and you seem pretty confident to me. As long as we all respect each other and respect this room, everything will be fine and you can represent yourself. I don't have a problem with that. But if we start crossing those lines, that's when we're gonna have a problem, okay? All right, I think that's it for today.
Thank you.
Right, thank you.
May I have a second for Mr. Renfro?
Yes.
Across both hearings, the same pattern repeats: assertions of sovereignty, rejection of court authority, and reliance on misapplied legal language like fruit of the poisonous tree, foreign agent, or consent to be governed. These ideas sound structured, but they operate outside actual court procedure. Courts don't evaluate belief systems, they evaluate admissible arguments, filed motions, and recognized law. When someone replaces procedure with ideology, they lose access to the very protections they're trying to claim. In the first case, refusing discovery closes off evidence that could challenge the prosecution. In the second, flooding the court with irrelevant filings damages credibility. Not because the court is ignoring rights, but because the arguments aren't legally valid within that system. There's also a deeper strategic cost. By choosing to represent themselves while rejecting the rules that govern the courtroom, the defendant places themselves at a structural disadvantage. The judge repeatedly offers pathways, discovery, scheduling flexibility, clarification, but those only work if the defendant engages within the system. Instead, each moment becomes a missed opportunity, declining evidence, misidentifying legal standards, and escalating claims that the court immediately dismisses as irrelevant. That pattern doesn't just stall progress, it signals to the court that meaningful legal engagement isn't happening. And when that signal becomes consistent, the court shifts focus from explanation to enforcement. Because in a courtroom, the outcome isn't shaped by how strongly someone believes they're right, but by whether they can prove it under the rules that actually apply.